Hello, everyone. Welcome to Internet Law Review. I hope you are having a fantastic day. We're here to discuss the case that I most anticipated this term, which is dealing with the separate sovereigns doctrine of criminal law. So, previous to this, if you committed an offense, you could be charged by both the state government and the federal government for the same underlying crime and same conduct. So, this has been a controversial issue in light of the Fifth Amendment's text. So, we're going to read quite a lot of the court's decision today. I've gone ahead and done um, what you might call a case brief or a book brief. When you're in law school, you kind of learn how to do basically highlighting of key parts of opinions to bring out the interest. And of course, no two law students, no two attorneys would do this exactly the same way. And also depends on like how much you want to stray from like core stuff and do auxiliary stuff. But this will give you a little bit of an idea of what goes on in my head when I do these things, because when you're in law school, you have to do this all the time. So you get down to the sort of core of what's interesting. But I've highlighted quite a lot in both the majority opinion and the dissenting opinion because I think it's a really interesting issue. We're going to go over a lot of history and going on. So first of all, we just have the disposition of the court in terms of the count. We have Justice Alito delivering the opinion of the court, and in dissent we have Justices Ginsburg and Gorsuch. So this is a 7-2 opinion of the United States Supreme Court, and we're going to read it and see what they have to say. Let's get started. All right. We consider in this case whether to overrule a longstanding interpretation of the Double Jeopardy Clause of the Fifth Amendment. That clause provides that no person may be twice put in jeopardy for the same offense. Our double jeopardy law case is complex, but at its core, the clause means that those acquitted or convicted of a particular offense cannot be tried twice for the same crime, same offense. But what does the clause mean by offense? We have long held that a crime under one sovereign's laws is not the same offense as a crime under the laws of another sovereign. Under this dual sovereignty doctrine, a state may prosecute a defendant under state law even if the federal government has prosecuted him for the same conduct under a federal statute. Or the reverse may happen, as it did here. Terrence Gamble, convicted by Alabama for possessing a firearm as a felon, now faced prosecution by the United States under its own felon in possession law. Attacking this second prosecution on double jeopardy grounds, Gamble asks us to overrule the double sovereignty doctrine. He contends that it departs from the founding era understanding of the right enshrined by the Double Jeopardy Clause, but the historical evidence assembled by Gamble is feeble, pointing the other way as to the clause's text, other historical evidence, and 170 years of precedence. Today we affirm that precedence, and with it the decision below. So, for the too long didn't watch portion of today's evening, the short answer to the question is yes. Both the state government and federal government can prosecute you for the same offense. That was true before, and it's true now. Now we're going to read a lot more about what's going on to understand the rationale of the court. But of course, we always should start with the factual background. In November of 2015, a local police officer in Mobile, Alabama, pulled Gamble over for a damaged headlight. Smelling marijuana, the officer searched Gamble's car where he found a loaded 9mm handgun. After Gamble pleaded guilty to this state offense, federal prosecutors indicted him for the same instance of possession under federal law, one forbidding those convicted of a crime punishable by imprisonment for more than a term of exceeding 1 year from shipping or transporting in interstate or foreign commerce or possessing in or affecting commerce any firearm or ammunition, otherwise known as the felon in possession law. So if you're convicted of any crime punishable by more than a year, federal law prohibits you from having a handgun. Gamble moved to dismiss on one ground. The federal indictment was for the same offense as the one at issue in his state conviction, and thus exposed him to double jeopardy. But because this court has long held that two offenses are not the same offense for double jeopardy purposes if prosecuted by different sovereigns, the district court gave the motion to dismiss, as of course the Court of Appeals, both the District Court and the Court of Appeals, were forced to do this because of precedent. So the only question is, will the United States Supreme Court reverse its precedent and change the mind? And the answer to that question is no. We start with the text of the Fifth Amendment. Although the double sovereign rule is often dubbed an exception to the double jeopardy right, it is not an exception at all. Well, I feel more reassured. On the contrary, it follows from the text that defines that right in the first place. The language of the clause protects individuals from being placed twice for the same offense, not the same conduct or actions. Okay? As originally understood then, an offense is defined by law, and each law is defined by a sovereign. So where there are two sovereigns, there are two laws and two offenses. Okay? Our case reflects the same reading. A close look at our cases reflects how fidelity, loyalty, to the Double Jeopardy Clause's text does more than honor formal differences between two distinct criminal codes. It honors substantive differences between the interests that two sovereigns can have in punishing the same act. The question of successive and federal state prosecutions arose in 3 antebellum, which means prior to Civil War, cases implying and then spelling out the dual sovereignty doctrine. The first involved an Ohio prosecution for passing counterfeit coins. The defendant argued that since Congress can punish counterfeiting, the states must be barred from doing so. Or else a person could face 2 trials for the same offense, contrary to the Fifth Amendment. We rejected the defendant's premise that under the Double Jeopardy Clause, offenses falling within the competency of 2 different authorities to restrain or punish them would not be properly subjected to consequences which those authorities might ordain and affix to their perpetration. Generalizing from this point, we declared in a second case that the same act, as to its character and the tendencies and the consequences involved, constituted an offense against both the state and federal governments, and might draw to its commission the penalties denounced by either, as appropriate to its character in reference to each. In a third case, we expanded on this concern for different interests of separate sovereigns after tracing it to the text in the manner set forth above, recalling that the Fifth Amendment prohibits double jeopardy not for the same act, but for the same offense, and that offense in its legal significance means a transgression of a law. We drew the now familiar inference. A single act may be an offense or transgression of the law of 2 sovereigns and hence punishable by both. Then we gave color to this abstract principle and to diverse interests that it might vindicate. With an example, an assault on a U.S. Marshal, we said, would offend against the nation and the state, first by hindering the execution of a legal process, and second by breaching the peace of state. That duality harms explains how one act could be punishable by 2 offenses for which the offender is justly punishable. And I guess that part at least makes sense. You know, the United States Marshal is a federal employee in execution of federal law in service to the federal court. But of course, if he's attacked, it's going to probably be in a state. And so that would be a breach of the peace and implicate state interest too. So at least as to that much, there are some separate interests that perhaps need to be recognized. But let's carry on. If, as Gamble suggests, only one sovereign may prosecute for a single act, no American court, state or federal, could prosecute conduct already tried in a foreign court. So this double sovereign doctrine also relates to law trials between the United States and other countries. So there's a lot of implication in what little case law that exists on this, that the double jeopardy clause could be read in a way that if you were tried in France, then the United States couldn't try you for the same offense either. So that's part of what it's concerning about there, about that issue. And obviously, U.S. interests and France interests might be distinct. But let's carry on. And the court gives an example. The murder of a U.S. national is an offense to the United States as much as it is to the country where the murder occurred and to which the victim is a stranger. That's while killing of an American abroad is a federal offense that can be prosecuted in our courts, and while customary international law allows this exercise of jurisdiction. The same idea that the Romans had, if you're a citizen of our country, no matter where you're killed, we will avenge you. So same idea here. So I take some mild comfort in the idea that if I'm overseas and killed, that my people can be charged twice. So hopefully that will help a little bit. We cemented this foundation 70 years after the last of these pre-Civil War cases in a decision upholding a federal prosecution that followed one by a state. Quoting, an act denounced as a crime by both the national and state sovereign is an offense against the peace and dignity of both and may be punished by each. And for decades more, we applied our precedent without qualm or quibble. And then we went on enforcing it by adding another 6 decades of cases to the doctrine's history. So basically, they're going for stare decisis, or the idea of res judicata, or the idea of precedent. All those phrases mean roughly the same thing, which means that once something is decided, it should be given effect and should be continued on, unless there's a good reason not to. So the majority here is laying out a foundation that we've been doing this for a long time. Okay, fair enough. And then this part I've highlighted in red, I highlighted because I thought it's particularly important. First, the dissents contend that our dual sovereignty rule errs in treating the federal government and state governments as two separate sovereigns, when in fact sovereignty belongs to the people. That argument is based on a non sequitur. Yes, our Constitution rests on the principle that the people are sovereign, but it does not mean they've conferred all the attributes of sovereignty on a single government. Instead, the people, by adopting the Constitution, split the atom of sovereignty. It is true that the Republic is one whole, but there's a difference between the whole and a single part, and the difference underlies our decisions as to foundational to our legal system as McCulloch v. Maryland, which is a foundational case in constitutional law that we don't have to discuss right now. But I think that this is actually a really interesting argument, and one that I had not previously considered in thinking about this issue, which may go to the idea that the Supreme Court is smarter than me, because they thought of a line of argument that I didn't think of, which is that when we normally talk about sovereignty, we normally talk about federal sovereignty as the United States, we talk about state sovereignty as the state of Virginia, for example, and the idea is that they can each have their own police, each can have their own laws, each can have their own enforcement mechanisms. I've talked about this before, but this idea here is basically saying that that entire conception is actually kind of wrong. In fact, if there not being two sovereigns, there's only one sovereign. And the sovereign is the king. And who is the king? Well, it is the people of the United States and their collective will. That is the sovereign, and the sovereign can do no wrong. And in this case, the sovereign chose to split its authority into two levels of government, federal and state, and then from there chose to split it into different branches of government and different levels beyond that. But I don't think the majority's conclusion is right that it's a non sequitur. I believe that that's wrong. If you talk about an atom of sovereignty, the whole point of the word atom is that it's unsplittable. So if you've split it into its two distinct wholes, then whatever you have left is not the material that you had before. So if you have a single atom of gold, for example, and you split that atom, then whatever you have left at that point is no longer gold. That's one of the things atom means, is indivisible. So if we have taken this sovereignty and split it, then whatever is remaining is not sovereignty. So we can talk about what the federal government has and what the state government has, but strictly speaking, under this view, it would not be sovereignty. Only with their powers combined would it truly be sovereignty, and then the states and federal government would be in some sort of collective mashup that all of its powers combined would be a single unit of sovereignty as reflected by the uniform will of the people. And to be quite honest, I think this is a pretty convincing argument. I really like its construction here, because then you could separate the idea of the sovereignty of France and the sovereignty of the United States from the relationship of the United States federal government to a state government, because that would be a distinct idea. It would be that we've split the sovereignty, but still the United States is some sort of collective whole, is still collectively sovereign. I haven't really thought through the full implications of that idea. I can't see any obvious problems with it because it wouldn't preclude double taxation, for example. In states, it's not uncommon for cities to have taxation authority, counties to have taxation authority. So it wouldn't preclude double taxation. It wouldn't necessarily preclude double regulation for the same reason: federal regulation authority, state regulation authority, city regulation authority. So, it wouldn't necessarily preclude double taxation, it wouldn't necessarily preclude double regulation, but it would sort of impact how you do the criminal law analysis, by preventing double jeopardy. So I kind of like this line of argument. And I think the majority is wrong that it's a non sequitur. I think they dismiss it without cause. But let's carry on. Gamble and his dissents lodge a second objection to this line of reasoning. They suggest because the division of federal and state power is meant to promote liberty, it cannot support a rule that exposes Gamble to a second sentence. Our federal system advances individual liberty in many ways. Among things, it limits powers of the federal government and protects certain basic liberties from infringement. But because the powers of the federal government and state government often overlap, allowing both to regulate often results in two layers of regulation. It's also not uncommon for the federal government to permit activities a state chooses to forbid or heavily restrict, for example, gambling and the state sale of alcohol. And a state may choose to legalize an activity the federal law prohibits, such as the sale of marijuana. Yes, I don't think this is an effective rebuttal to the idea of the split sovereignty concept, because you can do double regulation. I don't think it's a problem. You can have more than one police force, and those police forces can do more one thing. For example, no one would contest that the state of California is a sovereign, and no one would contest that neither the counties nor the cities nor any other level of local government is sovereign. The California is the sovereign, and it can do anything it wants with respect to its cities. It can abolish the cities, it can make them do anything it wants, but by the same token, it can have them have its local police authority, its local sheriffs, and stuff like that. So there's not really, in my view, an inherent conflict between the idea that there can be multiple levels of regulation with multiple law enforcement mechanisms, and you don't run into a problem. So, just because the federal government and state government and county government and city governments often overlap, often regulate into these multiple layers of regulation, to my mind, doesn't form the problem that is going on here. And as to the ability of the federal government to impose on states with respect to the federal law prohibition, well, we covered that before too. The 10th Amendment explicitly says the federal government's only given certain powers and states have reserved powers. So while a state can fully impose on a city and make them enforce its state laws, that doesn't hold true because the federal government doesn't have that same power. So although the federal government is supreme, its ability to dictate is more restricted because of the nature of the constitutional text. So I don't think this is as much a problem as the majority does, but let's carry on. Here, as noted, Gamble's historical arguments must overcome numerous major decisions spanning 170 years. In light of these factors, Gamble's historical evidence must, at a minimum, be better than middling, and it's not. The English cases are often a muddle, treatises offer spotty support, and early state and federal cases are by turns equivocal and downright harmful to Gamble's position. All told, this evidence does not establish that those who ratify the Fifth Amendment took it as a bar to successive prosecutions under different sovereigns' laws, much less to do so without enough force to break a chain of precedent linking dozens of cases over 70 years. So this gets to the value of how much you should hold precedent, which we'll get into a little bit later. Gamble's core claim is that early English cases reflected an established common law rule, barring domestic prosecutions following a prosecution for the same act under different sovereigns' law. But from the very dawn of the common law in medieval England until the adoption of the Fifth Amendment in 1791, there's not one reported trial case barring the prosecution based upon a prior trial of foreign law. Well, this would go to whether the Fifth Amendment was trying to establish a pre-existing right or codify some new right. And they would have to go into analysis here, which isn't really done, but let's carry on. Summing up the import of pre-ratification cases on which Gamble argument rests, and I will concede that they do have import, because when you're looking to a text, you're trying to interpret it in the vein in which it was understood at the time. So the question is, what do the people who passed this and ratified it mean it to mean? And so these prior gratification cases are not irrelevant, but you could think a little bit beyond that. But carrying on. Summing up the import of the pre-ratification cases on which Gamble's argument rests, we have the following. Not a single reported case in which a foreign acquittal or conviction barred a later prosecution for the same act in either Britain or America. Not a single reported decision in which a foreign judgment was held to be binding in a civil case in a court of law. Fragmentary and not entirely consistent evidence about the 17th century case in which a defendant named Hutchinson, having been tried and acquitted for murder someplace in the Iberian Peninsula, is said to have been spared a second trial for this crime on some ground, perhaps out of mercy, not as a matter of right, And there's like basically no case record, so no one knows exactly what happened. So that's just great. Two cases, one criminal, one admiralty, in which a party invoked a prior and foreign judgment, but the court did not endorse or rest on anything in the party's reliance on that judgment. And two courts of chancery cases, holding that foreign judgments were not treated as barring trial at common law. And courts of chancery were not courts that obeyed common law, so that's their dispositions are pretty irrelevant to our analysis. This is a flimsy foundation in case law for Gamble's argument that when the Fifth Amendment was ratified, it was well understood that foreign criminal judgment would bar retrial for the same act. Again, going to this, and this was a point of contention by Gamble's lawyers, and I can't necessarily fault them for what they did at the time, but in retrospect, it might have been better to try to argue that truly separate sovereigns can try for the same act, so to avoid this foreign criminal problem, and instead try to go into this idea that the federal and state government are not truly separate sovereigns. I can't blame Gamble's lawyers for their strategy or tactics. It wouldn't occur to me to make that kind of line of argument. The kind of line of argument they did make is the kind of line of argument I would try to make. So it's perhaps unfortunate that they didn't go down the different line, but no, I don't know if anyone would have thought of it. But yeah, that's how the breaks go sometimes. Anyways, carrying on. When we turn to 19th century treatises to 19th century state cases, Gamble's argument appears no stronger. The last we looked, we found these state cases to be inconclusive. They seem to be evenly split and in manifest conflict in conscience, rather than confident conclusions about common law. Indeed, two of those cases manifested nothing more than a misreading of then recent decisions of ours, and we see things no differently today. This is not a quantum of support for Gamble's claim about early American common law that might withstand his burden under stare decisis. Again, going to the level of respect you should give stare decisis. And once we look beyond the nation's earliest years, the body of state court dispositions appears even less helpful to Gamble's position. We aptly summarize those cases at Barkus and need not address that discussion here, but they put it in a footnote, so I'm going to read the footnote because I think it's important. As we put it in Barkus, of the 28 states which have considered the validity of successive state and federal prosecutions against a challenge of violation of either the state constitutional double jeopardy provision or a common law evidentiary rule of auforitas acquittus and auforitas convict, which means prior acquittal and prior conviction, 27 states have refused to rule that the second prosecution was or would be barred. These states were not bound to follow this court in its interpretation of the Fifth Amendment, because this would be prior to the incorporation, so that would be right. The rules, constitutional, statutory, or common law which bound them drew upon the same experience as did the Fifth Amendment, but were and are a separate and independent authority. Not all the state cases manifested careful reasoning. For some of them, the language concerning double jeopardy is but an offhand dictum, but in an array of state cases, there may be found a full consideration of the arguments supporting and denying a bar to second prosecution. These courts interpreted their rules as not prescribing a second prosecution when the first was by a different government and for a violation of a different statute. Yeah, I don't know exactly what they're referring to, and I think the interest of state to state double jeopardy might be slightly different than federal to state double jeopardy. If you view the whole thing as one sovereign, then you still have to deal with that issue, but I think it's a slightly different analysis. But let's carry on. Thus, of two federal cases that Gamble cites against the dual sovereignty rule, Houston squares with it, and Furlong supports it. Together with the muddle in the early state cases, this undermines Gamble's claim that early American bench and bar took the Fifth Amendment to proscribe successive prosecutions by different sovereigns. And without making a splash in the legal practice of the time, a few early treatises by themselves cannot unsettle almost 2 centuries of precedent. Besides appealing to the remote past, Gamble contends that a recent change, one doctrinal, one practical, blunt the force of stare decisis. They do not. I actually think they do, and we're going to see that in a minute. If historical claims forms the courses of Gamble's argument, his reference is incorporation. But incorporation changed everything. Argument trades on false analogy. For those of you who might not remember, in the original Bill of Rights, they did not apply to the states. The 14th Amendment changed that, and little by little, the Supreme Court has considered whether the Bill of Rights applies to the states, and almost all of them do, with very few exceptions. And this whole thing is known as incorporation. So basically, what Gamble is saying is that the Fifth Amendment, as originally understood, would only apply to the federal government. So all these decisions prior to incorporation from the states are not meaningful, because the states, not having it incorporated against themselves, wouldn't analyze the federal constitution because they don't care. But he said, and the court says this changes everything, trades on false analogy, which I don't think it does. But let's read on. Gamble contends that the incorporation of the double jeopardy clause should likewise end dual sovereignty rule, but the analogy fails. And then they talk about some of that stuff dealing with prior other criminal law, and then says, by contrast, the premises of dual sovereignty doctrine has survived incorporation intact. Incorporation meant the states were now required to abide by this court's interpretation of the double jeopardy clause, but that interpretation has long included dual sovereignty doctrine, and there's no reason why incorporation should change it. After all, the doctrine rests on the fest that only separate sovereigns' successive prosecutions are prosecutions for the same effect, and that's just as true as incorporation before. Yeah, this sentence drives me slightly crazy, because prior to incorporation, the federal constitution was irrelevant as far as the states were concerned. So all the states prior to incorporation that says there's no double jeopardy are irrelevant because it's prior to incorporation. After incorporation, the states were bound to the federal court's interpretation. So the Supreme Court, having said there's no double jeopardy, they were now required to say there's no double jeopardy. So therefore, all those decisions don't really apply either. Either they were ignoring it or they were bound by it. Either way, it's like they're of no value in interpreting what the Supreme Court should be doing now. So as far as I'm concerned, you can pretty much throw away all the state cases because they're completely irrelevant. So I think this is a very weak sauce kind of analysis on the part of the majority. Then the Supreme Court says, if incorporation is the doctrinal shift that Gamble invokes to justify departure from precedent, the practical change he cites is the proliferation of federal criminal law. Yes, it is. There is a lot of change there that's very relevant. But unlike Gamble's appeal to incorporation, this argument obviously assumes that dual sovereignty doctrine was a legal error from the start. Yeah. So the argument is only strong as Gamble's argument about the original understanding of double jeopardy rights, an argument we have so far found wanting. Insofar as the expansion of the reach of federal criminal law has been questioned on constitutional rather than policy grounds, the argument has focused on whether Congress has overstepped its legislative powers under the Constitution. Eliminating the dual sovereignty rule will do little to trim the reach of federal criminal law. I'm not sure that conclusion necessarily follows. First of all, I do take the view that the federal government's criminal law has far exceeded its bounds. I believe that because I believe the Commerce Clause jurisprudence is pretty much wrong, and therefore the federal government doesn't have the right to pass the vast majority of criminal law statutes that it does. And even if you assume that it does, yeah, the federal government's reach in terms of its statutes has grown dramatically. And so these sort of practical reasons are a common reason to overturn precedent. Unworkability is one. It's been pecked away little by little is another, and these sort of like changes on the ground are another reason. So the factual underpinning is a lot different today than it was before. So this would be a classic reason to overrule stare decisis, but they don't do it here, which is annoying. But let's carry on. Okay. Justice Thomas wrote a very, very long concurring opinion. I'm not going to read any of it because basically this entire long concurring opinion stands for the proposition that prior decisions are dumb, precedent is dumb, stare decisis is dumb, and we should just basically ignore it. So Justice Thomas is totally not a fan of stare decisis. He thinks that wrong decisions are wrong and that federal judges who have taken an oath to the Constitution should obey the Constitution regardless of what precedent says. So that's his view, that precedent is stupid, stare decisis is stupid, and we should just ignore it. So you now know everything Justice Thomas said in about like 20 pages. So let's carry on past that. Okay, so now we get to the dissenting part of the opinion. Question is, double jeopardy only fits if convicted then charged with the same crime. No, that's not true. It would apply if you're acquitted and then charged for the same crime. So double jeopardy goes both ways. So it doesn't matter whether you're acquitted or convicted. Double jeopardy would still apply. So yeah. Anyways, Justice Ginsburg dissent. Okay, in our compound republic, the division of authority between the United States and the states was meant to operate as a double security for the rights of the people. The separate sovereigns doctrine, however, scarcely shores up the people's rights. Instead, it invokes federalism to withhold liberty, which I'm intending to agree on. It is the doctrine's premise that each government has and must be allowed to vindicate a distinct interest in enforcing its own laws. That is a peculiar way to look at the Double Jeopardy Clause, by which its term safeguards the person and restrains the government. Another justification is precedent. In adopting the reaffirming the separate sovereigns doctrine, the court relies on dicta from 19th century opinions. And I'm somewhat inclined to agree with Ginsburg that the value of these precedent, even assuming you should look at them, is not that great. The precedent, even though there's 170 years of them, and it said a lot, is not what I'd consider to be particularly strong precedent, but that's my subjective opinion. Carrying on. The persuasive force of those opinions is diminished by their dubious reasoning, which I would tend to agree. When drawing on dicta from prior opinions, the court gave short shift to contrary authority. By the way, if you're not familiar with the term dicta, what it means is when the court is saying something that's not necessary for reaching the conclusion they reached. So if the court is opining on things that are not necessary to reach the opinion, that's what's considered dicta. So basically, it's stuff where it's like, yeah, here's some aside stuff, but it doesn't really matter. And as Ginsburg notes, the court sees the history as poor evidence in congressional intents, because she quotes here, first, the framers of the Bill of Rights voted down an amendment that would have permitted the federal government to re-prosecute a defendant initially tried by the state. Never mind that this amendment failed, the court has attributed the clause the very meaning the first Congress refrained from adopting. So the first Congress considered a clause that would have permitted double trials in some instances and then voted it down. The majority has taken the opinion that that's irrelevant. I don't know that I can agree. It's a little relevant. Finally, the court has reasoned that separate sovereigns doctrine is necessary to prevent either the federal government or state from encroaching on the other law enforcement prerogatives. Without this doctrine, the court has observed the federal government, by prosecuting first, could bar a state from pursuing more serious charges for the same offense, and conversely, a state, by prosecuting first, could effectively nullify federal law. And when federal-state tension exists, successive prosecutions for federal and state offenses may escape double jeopardy blockage under the tests prescribed in Blockberger v. United States. Offenses are distinct if each requires a proof of a fact which the other does not, referring to civil rights law. So this is a really important aspect, because even if you say that the double jeopardy clause should apply to the same offense, then you have to define what an offense is. And this is the standard the Supreme Court has come up with, which I tend to think is right, which is that each requires a proof of fact which the other does not. And this is also the same standard for when you're thinking about lesser included crimes. So if the state charges you with manslaughter is a lesser included crime of murder. The reason for that is that murder requires an element that manslaughter doesn't, but the reverse isn't true. Manslaughter does not require proving any element that murder does not. So if you've committed murder, you have also committed manslaughter, but of course, murder is the higher charge. So what this means is that if the state initially charges you with manslaughter and they fail, they can't come back then and charge you with murder. And vicariously, if they charge you with murder, they can't come back and charge you with manslaughter, because they're not distinct offenses, because they don't each require a fact the other doesn't. When you're looking at federal law versus state law, these often have an element the other does not. It's going to be very rare where you have an issue where both sets of laws are commingled in this way. So basically, they're saying that it's not that much of an issue in practice because the offenses are distinct, and I would tend to agree with that too. The dissent continues. The separate sovereign doctrine, I acknowledge, has been embraced repeatedly by the court. Before incorporation, the separate sovereigns doctrine had a certain logic. Without a carve-out for successive prosecutions for separate sovereigns, the double jeopardy clause would have barred the federal government from prosecuting a defendant previously tried by a state, but it would not have prevented a state from prosecuting a defendant previously tried by the federal government. Incorporation changed this, so that would be completely correct. Before incorporation, the federal government's constitution did not apply to states. Therefore, federal government could not try someone that had failed before in the federal or state level, but the reverse would not be true. And so this double jeopardy would have had a logic to it, but of course incorporation changed that, and I tend to agree with Ginsburg. Which is a sentence I don't say that often, but let's carry on. Before incorporation of the Fifth Amendment, privilege against self-incrimination, the court held the privilege did not prevent state authorities from compelling a defendant to provide testimony that could incorporate himself. Yeah, exactly, because the Fifth Amendment didn't exist as far as the state were concerned, so that you could force them to give testimony all you wanted. Yeah, exactly, right. The court regards incorporation as immaterial because the application of the double jeopardy clause to the states did not affect comprehension of the word offense to mean the violation of one sovereign's law. But the court attributed a separate sovereign's meaning to offense, at least in part because the double jeopardy clause did not apply to states. Duh, yeah, exactly. The court's interpretation of double jeopardy was influenced by the fact that the states were saying what they were saying because the federal government didn't apply to them. So this again, throws off the value of a lot of precedent in my view. Carrying on, incorporation of the clause should prompt the court to consider the protection against double jeopardy from the defendant's perspective and ask why each of two governments within the United States should be permitted to try defendants once for the same offense when neither could try him or her twice. That is a good question. In the last half century, however, federal criminal law has been extended pervasively into areas once left by the state. Yeah, a little bit. The run-of-the-mill felon in possession charges Gamble encountered indicate that, in practice, successive prosecutions are not limited to exceptional cases. Again, yeah. Against all this, there is little to be said for keeping the separate sovereigns doctrine. Gamble does not implicate the reliance interests of private parties. Yeah. So one of the reasons that stare decisis or precedent is a thing that exists is because of reliance value. Basically, the idea is that people should be able to rely on things to be steady, be predictable. We want things to be, understandable so we understand how to govern ourselves in our day-to-day lives. However, the reliance interest doesn't really apply to governments. Now, there's quite a lot of precedent that says that governments don't get to have reliance interests. They're the government. So, their reliance interest is zero. If the law changes, the law changes. That just happens to be what it is. You're the government. Deal with it. So carry on. The court apologizes. The dissent continues. Notably, the federal government has endeavored to reduce the incidence of same offense prosecutions. Under the petite policy adopted by the Department of Justice, the department will pursue a federal prosecution based on substantially the same acts or transactions previously presented in state court. Only the first prosecution left substantial federal interests demonstrably unvindicated, and department senior officials authorized the prosecution, which is true. In the prosecution manual for the Department of Justice, they basically say, we're going to enforce double jeopardy even if it's not required most of the time. I'm not sure why most of the time didn't apply in this particular case. And of course, it's just a guidance in their manual, which of course can be changed. So, not that encouraging. The dissent continues. In short, it is safe to predict that eliminating the separate sovereigns doctrine would spark no large disruption in practice. I tend to agree. Because of the petite policy, there's not that many cases where this comes up. So of, the 100 so cases where it comes up, you can deal. And no big problem. There's 100 less cases the federal government can bring every year. You'll live. All right, now we're going to carry on with Justice Gorsuch. Yeah, Nicholas Rizzuto, all that was Justice Ginsburg, not Justice Gorsuch. So now we're going to get into Justice Gorsuch's dissent. I know, but it reads kind of like a conservative opinion, doesn't it? So it's interesting that I would agree so much with Justice Ginsburg, and Justice Gorsuch would agree with Justice Ginsburg. So yeah, carrying on. A free society does not allow its government to try the same individual for the same crime until it's happy with the result. Yeah. Unfortunately, the court today endorses a colossal exception to this ancient rule against double jeopardy. My colleagues say the federal government and each state are separate sovereigns entitled to try the same person for the same crime. So, if all the might of one sovereign cannot succeed against the presumptively free individual, another may insist on the chance to try again. And if both manage to succeed, so much the better. They can add one punishment on top of the other. But this separate sovereign's exception to the bar against double jeopardy finds no meaningful support in the text of the Constitution, its original public meaning, structure, or history. Instead, the Constitution promises all Americans they will never suffer double jeopardy, and I would enforce that guarantee. Excuse me one second. Okay, let's carry on. Check. Okay. The rule against double jeopardy was firmly entrenched in both American colonies and England at the time of our Revolution, and the Fifth Amendment, which prohibits placing a defendant twice in jeopardy of life or limb for the same offense, sought to carry the traditional common law rule in our Constitution. As Joseph Story put it, the Constitution's prohibition against double jeopardy grew from a great privilege secured by common law, and that meant that a party shall not be tried a second time for the same offense after he's been once convicted or acquitted of the offense charged by the verdict of a jury and judgment has passed thereon for or against him. Incidentally, just as an aside, they say verdict of a jury because at this particular time in history, the Supreme Court had ruled that you could not waive a trial by jury. Trial by jury was mandatory. They didn't change their mind until I think 1950s, but don't quote me on that. So the reason Justice Story is saying jury is because you didn't have a choice at this time in history. But let's carry on. Given all this, it might seem that Gamble should win this case handily. Alabama prosecuted him for violating a state law that prohibits a convicted felon from possessing a pistol and sentenced him to a year in prison. Well, a year sounds like pretty good, but apparently not. Because then the federal government, apparently displeased with this sentence, charged Gamble under 18 U.S.C. 922 G1 with being a felon in possession of a firearm based on the same facts that gave rise to the state prosecution. Ultimately, a federal court sentenced him to 46 months in prison and 3 years as supervised release. Outstanding. So that's an additional 4 years. Just great. So the state 1 year wasn't enough. Let's give him another 4. Okay. Most ordinary speaker of English would say Mr. Gamble was tried twice for the same offense, precisely what the Fifth Amendment prohibits. Yeah. Tellingly, no one before us doubts that if either the federal government or Alabama had prosecuted Mr. Gamble twice on the facts, it would surely have violated the Constitution. Yeah. So how does the government manage to evade the Fifth Amendment so seemingly plain command? On the government's effect, the fact that federal government and state government split up the prosecutions made all the difference. Yeah. Though the double jeopardy clause doesn't say anything about allowing separate sovereigns to do sequentially, or incidentally simultaneously, although that'd be practically hard, what neither may do separately, the government assures us that the Fifth Amendment's phrase, same offense, does the work. As this court explained long ago in Blockberger versus United States, where the same act or transaction constitutes a violation of two distinct statutory provisions, the test to be applied to determine whether there are two offenses or one is whether each requires proof of the other when the other does not. So, if two laws demand proof of the same facts to secure prosecution, they constitute a single offense under our Constitution, and a second trial is forbidden. And by everyone's admission, that is exactly what happened here. The statute under which the federal government proceeded required it to prove no facts beyond the Alabama needed to provide under state law to win its conviction. The two prosecutions were for the same offense. That leads the government and this court to rest on the fact that distinct entities, federal and state, enacted these identical laws. This, we are told, is enough to transform what everyone agrees would otherwise be the same offense into two different offenses. Where that distinction is found in the constitutional text or original public understanding. We know the framers did not conceive of the term same offense in some technical way, referring only to the same statute. And if double jeopardy prevents one government from prosecuting a defendant multiple times for the same offense under the banner of such separate statutory labels, on what account can it make any difference when multiple governments collectively seem to do the same thing? Yeah, I tend to agree. The history of the double jeopardy clause supplies even more evidence yet. The original draft prohibited more than one trial or more than one punishment for the same offense. One representative then proposed adding the words by any law of the United States after the same offense. That proposal clearly would have codified the government's sovereign specific view, yet Congress chose to reject it. and which apparently, according to the majority, is completely irrelevant, which I do not think so. Viewed from the perspective of an ordinary reader of the Fifth Amendment, whether at the time of its adoption or in our own time, none of this can come come as a surprise. Imagine trying to explain the court's separate sovereigns rule to a criminal defendant then or now. Yes, you were sentenced to state prison for being a felon in possession of a firearm. And don't worry, the state can't prosecute you again, but a federal prosecutor can send you to prison again for the exact same thing. What's more, the federal prosecutor may work hand in hand with the state prosecutor who already went after you. They can share evidence and discuss what worked and what didn't the first time around, and the federal prosecutor can pursue you even if you're acquitted in the state case. None of this offends the Constitution's plain word protecting a person from being placed twice in jeopardy for life or limb for the same offense. Really? I share Justice Gorsuch's exasperation. This argument errs from the outset. The court seems to assume that sovereignty in this country belongs to the state and federal government, much as it once belonged to the King of England. But Chief Justice Marshall explained, the government of the Union is emphatically and truly a government of the people, and all sovereignty emanates from them. Alexander Hamilton put it this way: national and state sovereign systems are to be regarded not as different sovereigns, foreign to each other, but as one whole. Under our own Constitution, the federal and state governments are but two expressions of a single and sovereign people. And I really like this line of argument. It's like, what is the sovereign of the United States? The sovereign of the United States is the King of the United States. And who is the King of the United States? The people of the United States in their collective will. So we're each 1/300 millionth of a kingship, I guess, or something. But the point is that we, the people, are the sovereign. We, the people, have established this government with its splits and checks and balances and all kinds of fun stuff. But it's still one government created by us with all of its many sort of twists and turns. And ultimately, there's only one sovereign, the people. I kind of like this analysis, and I think it goes to constitutional text. Constitution does start, we the people. That's kind of a clue as to what's going on. But let's carry on. Yet today, court invokes federalism not to protect individual liberty, but to threaten it, allowing two governments to achieve an objective that was denied to each. The court brushes aside this concern because the powers of the federal and state governments often overlap, which often results in two layers of regulation. But the court's examples, taxation, alcohol, and marijuana, involve areas that under federal and state governments may each be regulated separately under the Constitution as interpreted by the court. And I would tend to agree because of the powers of each. That is miles away from the separate sovereigns exception, which allows the federal and state governments to accomplish together what neither may do separately, consistent with the Constitution's command. As Justice Black understood, the court's view misuses and desecrates, nice word, the concept of federalism. For it's just as much an affront to human freedom for man to be punished twice for the same offense by two parts of the people's government as it would for one to throw him in prison twice for the same offense. Yep, I agree. When they envisioned the relationship between the national government and the states under the new constitution, the framers sometimes referred to the way, by comparison, the relationship between Wales, Scotland, and England, and prosecutions in one of those places pretty plainly barred subsequent prosecutions for the same offense as the others. So, as for example, treatises explain that an acquittal of a murder as a grand sessions in Wales may be pleaded to an indictment for the same offense in England, for the rule is that a man's life shall not be brought into danger for the same offense more than once. It's kind of, the United States is a country of countries. They're United States. They're states. So the relationship is vaguely similar. So I like this analysis very much. The Supreme Court continues. In the end, then, it's hard to see how anyone consulting the common law in 1791 could have avoided this conclusion. While the issue may not have arisen often, incidentally, because there was basically no federal criminal law at the time, the weight of authority indicated that successive prosecutions by different sovereigns, even sovereigns as foreign to each other as England and Portugal, were out of bounds, and anyone familiar with the American federal system likely would have thought the rule applied with even graven force to successive prosecutions to the United States and a constituent state, again that both governments derive their sovereignty from the American people. Yeah. In 1931, the American Law Institute has stated that if a person has been acquitted in a court of competent jurisdiction for an offense in another country, he may not be tried for the same offense in an English court. And in 1791, an English judge explained that the bar in double jeopardy has always been applied whether a previous conviction or acquittal based on the same facts was an English court or a foreign court. The court asks us to assume that all these legal authorities misunderstood the common law ancient rule. I would not. Incidentally, I personally would have no trouble distinguishing between the United States and France and the United States and, Texas. I could very easily see the double jeopardy law only applies to the same sovereign, and it's all the same sovereign, so France can do whatever the hell it wants, and so can we. I would have no problem with that. So let's carry on. Why do you feel weird about agreeing with Gorsuch? I don't know. I mean, it's his analysis, so there you go. You're a Gorsuch fan, I guess. Who knew? Chancellor Kent wrote that the plea of Aforis acquittus, previously acquitted, rested on the prosecution in any civilized state, would be a good plea in any other civilized state. Thomas Sargent explained where the jurisdiction of the United States court and a state court is concurrent, the sense of either court, whether conviction or acquittal, may be pled in a bar to a prosecution in the other. William Rowell echoed the conclusion in virtually identical words. Indeed, one early commentator wrote that the principal reason for the double jeopardy clause was to prevent successive state and federal prosecutions, which he considered to be against the natural justice. Nor are these treatises purport to invent a new rule, but claimed only to recite the traditional one. United States versus Furling, one British subject killed another on the high seas, and the killer was indicted in an American federal court for robbery and murder. This court unanimously held that robbery on the high seas is considered an offense within the criminal jurisdiction of all nations, therefore can be punished by all, which is also known by a phrase called hostis humanis generis, the enemy of all mankind. Everyone has jurisdiction, so don't do these things. Great. The court unanimously held robbery on the seas as considered an offense within criminal jurisdiction of all nations that therefore can be punished by all. There's no doubt that a plea of auteur force acquittal would be good in any civilized state, though resting on the prosecution instituted in the courts of any other civilized state. In the face of so much contrary authority, the court winds up leaning on a single 1794 North Carolina Superior Court decision, State versus Brown, which again I would argue is irrelevant because the federal constitution didn't apply at the time. But the court's choice here is really revealing. True, Brown said a verdict in North Carolina would not be pleadable to a bar preferable against the defendant in a territory of the south of Ohio, but the court leaves what happened next. Brown went on to reject concurrent jurisdiction because trying the defendant according to several laws of each state could result him in being cropped in one, brandished and whipped in another, imprisoned in a third, and hanged in a fourth, and all for one and the same offense. The North Carolina court viewed that the result against natural justice, and therefore could not believe it to be law. Yeah, it is a little bit odd when you have death penalty in some places, not others, that you can be tried in multiple cases. Does that implicate some concerns about justice? I would tend to think it does, but the majority doesn't seem to for some reason. With the text, principles of federalism and history now arrayed and gusset, the government is left to suggest we should retain the separate sovereigns doctrine under the doctrine of stare decisis, a thing decided. But if that's the real basis for today's result, let's at least acknowledge this. By all appearances, the Constitution as originally adopted and understood did not allow successive state and federal prosecutions for the same offense, yet the government wants to tolerate this practice anyway. Stare decisis has many virtues, but when it comes to enforcing the Constitution, this court must take, and always has taken, special care in the doctrine's application. After all, judges swear to protect and defend the Constitution, not to protect what it prohibits. Yeah, I would tend to agree. It's an interesting thing what stare decisis is, but when your oath is to the Constitution, if the Constitution truly compels a result, how good can stare decisis really be at the end of the day? And while we rightly paid heed to the considered views of those who have come before us, especially in close cases, stare decisis isn't supposed to be the art of methodically ignoring what everyone knows. Indeed, blind obedience to stare decisis would have left this court still abide in grotesque errors like Dred Scott versus Sanford, Plessy versus Ferguson, and Korematsu versus United States, which dealt with the internment of Japanese citizens of the United States during World War II, if you're not familiar with that case. As Justice Brandeis explained, in cases involving the federal Constitution when correction through legislative action is practically impossible, this court has often overruled its earlier decisions. For all those reasons, while stare decisis warrants respect, it has never been an execrable command, and at its weakest when interpreted by the Constitution. And the reason for that is very practical. If you're interpreting a statute and you get it wrong, Congress can always overrule the statute. So having a strong allegiance to stare decisis is not that much a big deal because Congress can just whack the Supreme Court around and just say, okay, well, this is now what we want to do. Its ability to do that with the Constitution is much less flexible. So for that reason, stare decisis is normally considered to be at the weakest when interpreting constitutional text. And in my view, the stare decisis prior decisions, although there's like 170 years or 70 years of it or whatever it's supposed to be, I forget, but the cases are weak. I think they're weak. The state cases are irrelevant. There's not much federal cases, and I just think, I just think the stare decisis for the precedent is pretty garbage. So carrying on. Nor has only the law changed, the world has too. And when far-reaching systemic and structural changes make an early error all the more egregious and harmful, stare decisis can lose its force. And now it's going to make this point. In the era when separate sovereigns exception first emerged, federal criminal code was new, thin, modest, and restrained, to the point of basically not existing. Today, it can make none of those boasts. Some suggest that the federal government has now duplicated virtually every major state crime. A little bit. Others estimate the U.S. Code contains more than 4,500 criminal statutes, not even counting the hundreds of thousands of federal regulations that can trigger criminal penalties. No one knows how many federal crimes there are, which is always a great concern, isn't it? Still, others suggest that there's no one in the United States over the age of 18 who cannot be indicted for some federal crime. I would strongly agree. There was a book written by a law professor called 3 Felonies a Day, which, as the title suggests, every person commits 3 felonies a day, regardless of whether it's actually that number or not. If you think hard enough, you can indict everyone. In fact, I don't know if this is still a thing. I imagine it is. But the Department of Justice attorneys used to play a game where they would say, take a random person and find the most obscure but most plausible thing you could charge them with. And the idea was the more obscure but more plausible, the better. So it's basically a challenge to figure out like what's the best you can do. So you take someone like Mother Teresa, who basically never visited the United States. I think she did like once or twice, but she didn't live here. And you say, what can we charge her with? And then you start to think of things, and you can always think of something because there's a lot of federal statutes. You can always find something. Give me a person, and I'll figure out what I can indict them with. Carrying on, the dissent argues, if long ago the court thought that the benign spirit of prosecutors ran unwavering enforcement of the Constitution's sufficient protection against the threat of double prosecution, it's unclear how we still might. Yeah. Which only leaves the reliance interest, which again is a classic reason of stare decisis, reliance interest. But the only people who have relied on the separate sovereigns exception are prosecutors who have sought to double prosecute and double punish. And this court has long ago rejected the idea that law enforcement reliance interest outweighs the interest in protecting individual constitutional rights so as to warrant fidelity to an unjustifiable rule. Instead, if it's clear practice is unlawful, individuals' interest in discontinuance clearly outweighs any law enforcement entitled to persistence, and that's the case here. And I would go so far as to say that governments never have a reliance interest, screw them. The dissent continues. The court today disregards these lessons. It worries that overturning the separate sovereigns rule could undermine the reliance interests of prosecutors in transnational cases, which might also prohibit them from trying individuals already acquitted in a foreign court. Yet, even in its own terms, this argument is unpersuasive. The government has not even attempted to quantify the scope of the alleged problem, and perhaps for good reason. Domestic prosecutions regularly coordinate with their foreign counterparts when pursuing transnational criminals, so they can often choose the most favorable forum for their mutual efforts. And because the Blockburgers requires any identity of elements before double jeopardy bar can take hold, domestic prosecutors armed with their own abundant criminal codes will often find new offenses to charge if they're unsatisfied with the outcomes elsewhere. Yeah, basically the same thing. I don't begin to know how murder is defined in France, but I'm willing to bet that it's different enough that it would not meet the Blockburger test with any state or the United States federal government. So, carrying on. And if it's that much a problem, we can amend it to fix that problem. So, anyways. The separate sovereigns doctrine was wrong when it was invented, and it remains wrong today. I respectfully dissent. Back to the top of the page. All right, so we're back here to the top of the page. So, that, my friends, is the case of Gamble versus United States. Yeah, I have to say that I agree with the dissent on this one. Stare decisis is important, But, it can't be so rigid that we never overturn anything, because then Plessy versus Ferguson would still be the law of the land, and that doesn't work. And I don't know if it can go so far as to be non-existent, because if it were non-existent, then pretty much every 5-4 decision would presumably be up for grabs. For that matter, 9-0 decisions would be up for grabs, because there's quite a few that had strong majorities that I'd like to overrule if I could. So it has to be somewhere in between. Normally, you look to things like whether it's become unworkable, whether people haven't relied on it, whether it's become unworkable because it's been beaten to death by, too many exceptions being made. Look to reliance interests. These are the kind of things that stare decisis normally gives a view for. This was what O'Connor said, incidentally, when she upheld the right to abortion in what's the name of the case? I can't believe I can't remember the name of the case. Casey versus Planned Parenthood. Thank you. That's the name of the case. These were the 4 factors she listed, and I tend to think it's right. Here, I don't think the precedent is any good. I think the state law precedent doesn't make any sense, because they either ignored the federal constitution or were forced to obey it. And I think what constitutes the same offense would make this less of a practical problem. And if it is a practical problem, they can amend their ways out of it pretty easily. So I don't know that's that much an issue. So yeah, I would go the other way on this one. I'm disappointed. I can understand some of the people in it that went the other way, but it's like, I mean, look at who went this way. I mean, Breyer, Sotomayor, Kagan, they voted to uphold this. I mean, Kagan I can kind of understand. Sotomayor, Thomas is also a bit of a surprise, because he has no value of precedent whatsoever. He doesn't care. He spent like 20 pages saying that. So the fact he still thinks it goes the other way is kind of a surprise to me. Roberts is an institutionalist, but he's overruled some decisions recently, so I don't know what he's thinking. So that's basically everything. All right, anyone have any questions beyond what we can hear? Is there a provision in the Constitution to call useless, conflicting, or severely out-of-date laws short of constitutional convention? Well, they're laws, then the legislature can just overrule them at any time. If the constitutional provisions, no. But that being said, if there's like really old provisions in law that basically haven't been used for a sufficiently long time, then you get into lots of issues with reliance interest too, because it's one of these things like it's on the books but no one knows, and so yeah, let's frame an amendment to end this practice. Then we already do that. Let's see, is there any other questions? If not, I'll end the stream. I don't see any questions. All right, guys, I've been doing this an hour. Did Thomas just get into stare decisis right and forget to make an opinion? No, he agreed. He agreed with the majority. He agreed with the majority. He wrote a concurring opinion saying stare decisis is stupid, but he agreed with the majority opinion, which is amazing, because if you think stare decisis is stupid, then still saying this is the right result is strange, but that's what he wrote. Yeah, this is one where I'm going to have to agree with the minority, and I don't know there's any way to fix this again. Well, there is one way to fix it, actually. You could fix it by statute. You could get Congress to pass a law saying that, no federal prosecutor could bring a charge if it would be double jeopardy, blah, blah, blah. So you can do it by statute, because the Constitution is a floor, not a ceiling. So Congress can always pass a law that gives more rights than the Constitution does, because it's a floor, not a ceiling. So lobby your legislatures in Congress, I suppose, to get them to pass a bill that, undoes this by statute, and hope for the best, I suppose, because I don't know what else to do. Yeah, good luck getting Congress to pass a law. I don't know. I have some hope in my heart that there are enough. I don't know, because like a lot of the left members of the court didn't agree with this either. So I don't know. I think there might be enough conservatives and liberals who go with the other side on this. Um, this doesn't strike me as a particularly conservative opinion, even though it's written by Alito. I wouldn't describe it as a liberal opinion either. Um, I don't know what I describe it as. It's strange. Um, if they held that the Fifth Amendment did provide this double jeopardy and both sovereigns indicted, what would have precedence? Yeah, that's a good question. I think until Congress passed a law on it, it would be whoever got to the courthouse first. Um, although arguably it would be like whoever can. Well, then you have to decide when double jeopardy attaches. So there's actually a split of authority on this. Um, some are, as best as I recall, this is a split of authority. Some jurisdictions take the view that double jeopardy attaches as soon as the jury is sworn in. Some jurisdictions take the view that double jeopardy attaches as soon as the first witness starts to testify. Now, in practice, there's not much of a difference between those two things, but every once in a while it does pop up. I don't think supremacy clause is the answer, because I don't think that's the answer. But Congress could fix it with statute. If Congress passed a law saying we get priority if we indict or we have first dibs or like something like that, I think they could do that. So if Congress passes a law to say we get first dibs or the states get first dibs or whatever the answer to that question is, because you could also have two states which could possibly indict for the same offense. So, my favorite go-to example, I don't know why, I just find it entertaining, is a person kidnaps someone in state one and travels through 9 states and then is caught. So you have 9 states who have an interest and the federal government. So you have 10 possible jurisdictions. So who gets to do this thing? Um, so you probably would want Congress to pass a law that says who gets priority. Otherwise, I think it's whoever gets there first. Um, but it hasn't been that much an issue so far because those kinds of situations are so far and few between. It's not that much to worry about. But yeah, I think Congress could fix it by statute. Can Congress really deny the ability to prosecute states for its own laws? Quite possibly. There's this idea of preemption, where basically you preempt the field. So if Congress, yeah, I think they could do it. I think the supremacy clause would get them there. It's not that they deny the state's ability, it's that they basically say we get it first. And because of the supremacy clause, I think that would work. I think they could do it constitutionally. It certainly would be a whole lot better than this. Anyways, this has been an hour-long stream. This has been the decision I've been most waiting for. Having read it in some detail and having shared it with you in some detail, I'm disappointed. I really think it should have gone the other way. I think Ginsburg had it right, which is a sentence I don't say that often, and I think Gorsuch had it right. And yeah, is Kevin on this thing? Hold on. Yeah, Kavanaugh's in the majority too. That's surprising, man. Jeez, that's rough. Oh well. Anyways, I'm gonna end the stream. Until later, my friends. Cheers. Goodbye. Find the end button.